Satvika, I think you can begin.
Okay, thank you. Very good afternoon to one and all. We are back with the third and final day of the sixth Intra Moot Court Competition 2021. On behalf of the Moot Court Society, I, Satvika Dikshit, Deputy General Secretary of MCS, extend my warm and cordial welcome to all the dignitaries, professors, and students. From the first day, the competition has taken off on full steam. The enthusiasm among the participants was in full display as the teams took one another in a challenge that is as exciting as it is invigorating. As the team charged ahead with their impressive arguments, debating skills, and counterviews, the session now for sure is set to get more engrossing. The participants have prepared themselves with knowledge, experience, 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 experience,
I think Satvika has lost her internet connection, but we'll proceed further with the rounds.
Okay, I'm here. Am I audible?
Yes, you can go ahead.
Yeah, thank you. As the team charged ahead with their impressive arguments, debating skills, and counterviews, this session now for sure is set to get more engrossing. We are feeling elated for the last day, and we hope our elation is contagious to the participants as well. The past 2 days have been truly memorable for everyone. We would like to express our heartiest congratulations to all the teams qualifying for the finals, and at the same time, we would like to express our good wishes and gratitude to all the other participants for taking part in the event and giving it their all. I'm profusely elated to have this opportunity to introduce our judges for the final round of the sixth Intra Moot Court competition. Starting with our first judge, we have with us Mr. Sheetal Sethia sir, who is an assistant professor of law at University of Mumbai since October 2012. Sir has expertise in teaching Indian constitutional law, law of insurance, trademarks, industrial design, IT protection of and enforcement of human rights, etc. Sir did his LLB and LLM from Punjab University, Chandigarh, and has actively participated in many national and international conferences. Sir has also been an invitee speaker in the refresher courses conducted by the UGC HRDC University of Mumbai. Thank you for gracing us with your presence, sir. Next, we feel honored to have with us Advocate Gajanan Chavan, who is a well-known advocate and has practiced exclusively in criminal law since last 40 years in Thane, Kalyan, and Vasai Sessions Court. Sir has dealt over 2,500 session cases and about 1,500 cases under NDPS Act. We are honored to have you, sir. Next, it's my privilege to welcome the third judge of the final round, Dr. D.K. Sonavne, sir. Dr. D.K. Sonavne, sir, is a retired judge and is now an academician. He completed his master's and doctorate in law from University of Mumbai. He practiced as an advocate in Mumbai from 1983 to 1990. Currently, sir is teaching law at post-graduation level at University of Mumbai, Department of Law. Thank you all. Now, moving on to the final round. The allocated time for the final round is 30 minutes for each team, with additional time of 5 minutes for rebuttal and sir rebuttal. TC 13 are representing petitioners, with Speaker 1 speaking for 20 minutes and Speaker 2 speaking for 10 minutes. TC 4 are representing respondents, with Speaker 1 speaking for 10 minutes and Speaker 2 speaking for 20 minutes. So now, the gongs are beaten and the bells are rung as the sixth Intra-Moot Court competition moves forward to the fiery stages with the commencement of finals. The teams are armored with their arguments and memorials as the final fight for the title is about to begin. The virtual stage is all set up and the audience are ready to recognize the hard work and team spirit displayed by the participants. May the victory serve the worthy, and may the light of knowledge grace us all. With this, let us begin with our most awaited final round of the sixth Intra Moot Court competition. Team 13, you can start with your submissions.
May the council have the permission to approach the dais? Yes, please. Please
Much
go ahead.
obliged. May the council have the permission to jointly refer the bench as your lordship?
Please continue.
Much obliged. This is counsel appearing on behalf of petitioner in the case of ULU and OTT Consortium versus Union of Indica. This is counsel 1 and will be dealing with issues 1 and 2 of the case, and my co-counsel will be dealing with issue 3 of the case. If your lordship are well versed with the facts of the case, the council seeks your lordship permission to address the issue.
Learned counsel, if there are any facts which you would like to draw special attention on through your arguments, you might highlight them in brief.
Much obliged. Due to the pandemic of COVID-19, the option for entertainment were limited to OTT platforms. This led to a rise in demand, and the OTT platform began the domestic original production. Code of online curated content providers was adopted as there was objection seen for the published content on various grounds of obscenity, nudity, and vulgarity. Yulu, one such OTT platform, released teasers and trailers for its web series Chandak on January 1st, 2020. It was met with a backlash and condemned on 6 scenes shown in the trailer. The authority called for the disbanding of the protests, which led to widespread discontentment amongst the citizens. This led to violence and destruction of property, and soon communal riots spread across Indica. The makers of the controversial web series Yulu issued an unconditional apology and also removed the parts of the series that were said to be objectionable. The controversy also spurred demands for the censorship and criminal penalties for the OTT and OCC platforms. Subsequent to the above events, the Ministry of Electronic Information gave its assent to Information Technology Rules 2021, which came into effect from February 5th, 2021. The OTT Consortium with Yulu at the helm challenged Section 3 of the rules in a public interest litigation under Article 32 of the Constitution of Indica. The respondent alleged that Yulu played a pivotal role in instigating the riots all across Indica and are demanding its arrest and prosecution for the crime against humanity. Yulu, on the other hand, filed a petition challenging the multiple FIRs under Section 153A and 295A of the Indian Penal Code and claimed that the corporation cannot be held liable for the communal riots that took place in January 2021. The council seeks your lordship permission to address the issue.
Please proceed.
Much obliged. The first issue tabled before us is whether the PIL filed is maintainable before the Honorable Supreme Court of Indica. The Council for Petitioner humbly submits to the Honorable Supreme Court that the present PIL is maintainable under Article 32 of the Constitution against the Union of Indica, as there has been gross violation of Article 19 of the Constitution. As mentioned under the facts, the OTT Consortium with Yulu has filed a PIL under Article 32 of the Constitution of Indica on the grounds that the rules are framed in an ambiguous and vague manner to restrain the right to freedom of speech and expression. These restrictions are being seen as an extraordinary and unreasonable constraint on the business and trade. The original jurisdiction of Supreme Court can be evoked in any case of a violation of a fundamental right which is guaranteed by Part 3 of the Constitution, as observed in the case of Chiranjit Lal Chaudhary versus Union of India. The Constitution makers conferred upon the Supreme Court the power to issue writs for the speedy enforcement of fundamental right and made the right to approach the Supreme Court for such enforcement itself is a fundamental right. Yulu is approaching the Supreme Court as their fundamental right has been violated on the ground that there has been restraint on freedom of speech and expression and restraint on trade and business. As it was observed in the case of MS Book India Limited versus State of Jharkhand, the court held that when it is to be believed that an individual is a distressed party to challenge the legitimacy of a complaint presented, it would have the locus standi to retain the formal grievance. Also stated in the case of MS Nadin Plastic Limited versus Hindustan Photo Films Manufacturing Company Limited, it was observed by the Supreme Court that the wider concept of locus standi in public interest litigation moved before the court under Article 32 of the Constitution of India, which also refers a constitutional remedy cannot be imported for deciding the right of appeal. Therefore, they are capable of being bona fide. Freedom of speech and expression includes the right to express one's opinion on any matter by any means. Therefore, it shows the right to convey one's opinion. The preamble of the Indian Constitution describes the freedom of thought, expression, belief, faith, and worship. As observed in case of Romesh Thapar versus Union of India, Justice Patanjali held that Article 19(1) subclause A is the very basis and essence of the Constitution and the democracy. This case was further supported by Menka Gandhi versus Union of India. Justice Bhagwati has emphasized on the significance of freedom of speech and expression in these words. Democracy is fundamentally based on free and open debate, for that is the only corrective of government action in a democratic setup. If democracy means government of the people and by the people, it is clear that all the citizens must have the right to participate in democracy and exercise their right to choose wisely. Speaking about democracy, freedom of thought and expression was presented as the most important fundamental value of our constitutional system. Freedom to express one's opinion is the lifeline of democracy, and attempts to suppress this right would contradict the established democracy. Therefore, freedom of expression is essential for the establishment of a democratic constitution. As the case of Justice K.S. Puttaswamy versus Union of India states, the right to freedom of speech and expression is guaranteed freely by word of mouth, writing, press, images, and other means. When a person talks on a phone, that person is exercising their right to freedom of speech and expression. Telephone taping, unless it comes within the ground of restriction under Article 19, subclause 2, it would infringe Article 19(1) subclause A of the Constitution. Restrictions have affected the freedom of speech and expression and the right to free trade, as mentioned in case of Chintanman Rao versus State of Madhya Pradesh. The term reasonable restriction means that the restriction imposed on the right holder must be in arbitrary or apologies. The term reasonable restriction means the restriction imposed on the right holder must not be arbitrary or excessive in nature beyond what is required for the good of the public. Also, in
Learned Counsel, if I may disrupt you here, kindly contextualize whenever you're quoting, whenever you're citing a judgment, telephone tapping and issues which do not directly relate to the issue at hand. Well, you'll have to establish if they, in any sense, connect with this issue which we are discussing. So, whenever you are citing cases, please ensure that you relate them to the matter at hand.
Indeed, Your Lordship. May the counsel proceed? Your Lordship, may the counsel proceed?
Please continue.
Much obliged.
Please continue.
Also, in the recent case of Supreme Court, State of Gujarat versus Mirzapur Moti Qureshi Kasab Jamaat stated a total prohibition under Article 19 subclause 2 to Article 19 subclause 6 must satisfy the test that a lesser alternative would be inadequate. The court held that banning a film has other meanings. Film ban not only affect the freedom of speech and expression of directors and producers, it also affects the economic aspects of the people. Directing, distributing, showing are important aspects of the film industry. And if a movie is banned, this falls under Article 19 subclause G. This concerns all aspects that are explicitly mentioned. It is humbly submitted before the Honorable Supreme Court that, as stated in the facts, the right to freedom of speech and expression has been violated, and thus the concerned PIL is maintainable under Article 32 of the Indian Constitution. If the Lordship are pleased with the argument, may the Council have the permission to deal with the remaining issue? Your Lordship, you're not audible.
Please go ahead.
Much obliged. The council on behalf of the petitioner humbly submits before the Honorable Supreme Court of India that the act of regulation...
Excuse me, sorry, Dr. Sunamne wanted to say something, but Dr. Sunamne, your mic is on mute.
Can you hear me now?
Indeed, Your Lordship.
Yes.
Yeah. So just now, Justice Shital Kumar put a question to you that you refer a case which is not relevant. So please satisfy us on what point that case is relevant with the facts case in hand. What is the relevancy of that case you have referred to now? Because you have placed rely upon it, no? What is the relevancy?
Indeed, Your Lordship.
What is that? So we like to know the relevancy.
Indeed, Your Lordship. As the case of Justice K.S. Puttaswamy versus Union of India states, the right to freedom of speech and expression is guaranteed freely by word of mouth, writing, press, images, and other means. When a person talks on a phone, that person is exercising their right to freedom of speech and expression. Telephone taping coming to the point unless in the ground when it is in the restriction. That is Article 19, subclause 2. As Your Lordship, as my co-counsel is representing the compendium, it has been highlighted. The facts are being highlighted.
Okay.
May the
Okay,
counsel proceed?
Yeah, proceed.
Much obliged. The council on behalf of the petitioner humbly submits before the Honorable Supreme Court of India that the act of regulating content as given under Section 3 of IT Rules 2021 is constitutionally invalid. Section 3 of the IT Act is constitutionally...
Learned Counsel, if I may disrupt at this point, the first argument was regarding Article 19. And the basis, as I could understand, of your argument was, as this court could understand, was that it allows for freedom of speech and expression. Now, is that unregulated expression? Any regulation of expression? Is Article 19 a license to say whatever we want? How free is the expression allowed under Article 19? Are there not reasonable restrictions on this right?
Indeed, Your Lordship, there are reasonable restrictions that can be imposed, but in the present case, there was only creativity. It was the freedom of creativity that Yulu is taking the defense of creativity. It is on the part of the respondent that they are relating it to the real life. It is already mentioned in the disclaimer before the web series that what kind of content is going to be published. And the viewers, the subscriber are all accepting the terms and condition and then further going ahead and watching it. So it is not on the part of the petitioner. They have already issued a disclaimer which has provided with all kind of information that what kind of content is going to be published on their platform.
Learned Counsel, the question was, can anything be expressed? Are there any limitations on expression under Article 19?
Indeed, Your Lordship. There are certain reasonable restrictions that can be imposed by the respondent or the Union of India. They can impose a reasonable restriction when a disharmony is spread, or when the question of peace comes, or sovereignty or integrity is in danger. Only then. But in the present case, petitioner hasn't infringed any. The petitioner hasn't violated any guidelines or the law that were provided in the prop itself. So we are pleading before the Supreme Court that we are not liable.
No, but there is a scene in that serial that one Kusli man kisses Sindhu woman, and that too at the background of a temple. Is not the violation or insult to a religion?
Indeed, Your Lordship, the petitioner issued an unconditional apology and also removed the objectionable part, and then went ahead with the release of the series. All the objectionable part were removed at the first hand, and only then the web series was released by Yulu. So further now, if the respondent are again imposing restriction on us, then that is unreasonable and beyond what is required.
Okay. Proceed ahead. Proceed ahead.
Much obliged. Section 3 of the IT Act is constitutionally invalid. This is because the trailer of the web series was released on 1st January 2021. Then the series was released on February 1st, 2021. And the Section 3 of the IT Act came into force on 5th February 2021. As mentioned by the Koch maxim, a new law ought to be prospective, not retrospective in its operation. Apologies. If the law, if the law is of retrospective operation, then it will go against the basic structure of the doctrine. And since the law was enacted post the series was released, it has a retrospective operation attached to it. Further, Justice Subbarao supported that a law needs to have a prospective nature on two grounds. Foremost, this prospective nature would be applicable if it is a matter relating to the Constitution. And secondly, only the Supreme Court has a say to it. He says that the power of the Supreme Court to declare the law under Article 141 also inheres in the power to declare the law should have a prospective effect only. There have been instances of various web series, such as Sacred Games, Patal Lok, Mirzapur, wherein there were protests and disagreement about the release. But in the end, these web series were eventually released. So, if Section 3 is made constitutionally valid and a ban is laid on the web series Chandak, then this would actually be an infringement of Yulu's right to equality under Article 14. Article 14 states that there is a fundamental right to equality, but amongst the equal. Now here, the equal would be all the OTT platforms and the shows released by them. Now that the Honorable Court has permitted to release the various series, the Supreme Court here is the guardian of the fundamental right. So here, it needs to take the utmost care to see that the fundamental right to equality is not infringed, either by letting Chandak be released. Section 3 is unconstitutional because it violated Article 19, freedom of speech and expression, and Article 19, subclause G, that is, freedom to free trade. Apologies. According to some of the web series supporters, Article 19 plays an important role in the controversy. It supports the action of showing adult content without any restriction. In the case of Sri Anand Patwardhan versus Center Board of Film, a movie was made in which some scenes were objected by the censor board and alleged that they came under the ambit of Section 295A. Court held that the cuts suggested were not reasonable and violated the right of freedom of expression. Similarly, the Section 3 of IT Acts states Yulu to regulate the content which is unreasonable and is an infringement of fundamental right of Article 19 as well as Article 19(1) subclause G. My co-counsel will be dealing with the remaining issue.
Learned counsel, at this point, if this court may ask, what are the grounds on which you are challenging Section 3 here? Is it because it is retroactively applicable to you, or is it because it is violative of Article 19?
Indeed, Your Lordship. Your Lordship, Section 3 of the IT Act is violating the fundamental right of freedom of speech and expression as well as freedom to trade. Both the fundamental rights of the petitioner are being vigorously violated by them. Because Section 3 came into force after the release of the web series. Therefore, and Annexure 1 already existed when the web series was released. So, petitioner hasn't violated any of the points that are stated in Annexure 1, and it won't, and Section 3 of the IT Act won't be applicable in the present case.
Learned Counsel, I don't think we are here talking about Section 3 of the Information Technology Act. We are talking about a set of rules, right? Or an additional code that has been passed. It's not the IT Act, I think, which we are talking about. The Section 3 of what is it?
Your Lordship, it is Section 3 of the IT Act, Annexure 2.
Let's continue.
My co-counsel will be dealing with the remaining issue.
Please.
Much obliged.
May the council have the permission to approach the dais?
Yes.
Much obliged. May the council have the permission to jointly refer the bench as lordships?
Yes. Yes.
Much obliged. The next issue tabled before us is the council, on the behalf of the petitioner, humbly submits before the Honorable Supreme Court of Indica that Yulu cannot be held liable under Section 153A and 295A of the Indian Penal Code. Foremost, the allegation that the 6 scenes that spurred a controversy were deliberate to hurt the religious sentiments are false. This is because the scenes that were shown were the essential of the plot story and were meant to be taken as the part of entertainment without correlating it to the real life. And as held in the case of the movie Bandit Queen, the controversy was spurred then too about the vulgar and sexual scenes. But it was argued then too by the makers that the scenes that are deemed to be vulgar are actually the one that are strengthening the plot of the movie. And this judgment was upheld in the true essence of it. Also in the case of Mahendra Singh Dhoni versus Yera Guntala Shyam Sundar, Section 295A penalizes only those acts or attempts to insult which are perpetrated with deliberate and malicious intention of outraging religious feelings of a particular class of citizens. Any kind of insults that are made carelessly or unwittingly without any malicious intention are not covered under this act. Secondly, Sikh, one of the community which alleged whose religious sentiments were hurt on the grounds that Yulu showcased a scene where the lead actor throws away his kada in the sea. Here, as mentioned, Section 101 and 103 of the Indian Evidence Act, the respondent needs to prove beyond reasonable doubt that the kada used in the scene was the one used by the Sikh community as religious practice and truly belonged to them. And since this remains ambiguous and unclear as of now, Yulu cannot be held liable under Section 153A and 295A of the Indian Penal Code. Also, as mentioned in the case of Rajkumar Verma versus Nandan Kumar Verma and others, has clearly laid down that the burden of proving a fact always lies upon a person who asserts the facts. So as mentioned in the present case, it is upon the respondent to prove the allegation. And until such a burden is discharged, the petitioner is not required to be called upon to prove his case. Thirdly, when any viewer who is also the subscriber subscribes to the OTT platform, they agree to the terms and conditions placed before them. And these terms and conditions provide about the nature of content being shown, and also that the viewer discretion is highly advisable. Even after this, if the user or the viewer or the subscriber chooses to watch it and then get emotionally hurt by the content being published and chooses to riot, how can Yulu be held liable for the same under Section 153A and 295A of the Indian Penal Code? Fourthly, when the trailer or the teasers of the web series Chandak were released, it was alleged that Yulu hurt the public sentiments and a backlash was seen on the release of the series, which was much later with the proposed changes. Yet, the mob went on to riots and damaging the public property. Now, this was merely based on speculation, prejudice, and false perception that the web series was released on the indicative norms of hurting the public sentiments and causing disharmony between the religious groups. This was also observed in the case of the movie Jolly LLB, wherein the Delhi High Court had held that the case so filed could not be maintainable as it was based on the trailer of the movie. Yulu cannot be held liable on the mere basis of speculation, prejudice, and false perception under Section 153A and 295A of the Indian Penal Code. Lastly, these OTT platforms are into the trade of entertainment. Any trade for that matter uses a simple economic principle, that is, if the demand rises, the supply would follow. So if the majority of the viewers seek to watch the web series, the makers will make it and the OTT platforms will release it. The viewers were not coerced or were not forced to take up the subscription of the same and watch the web series. And even then, as pronounced in the case of the movie PK, Justice Lodha had remarked, if you don't like it, don't watch it. Talking about the economical aspects, making a web series involves numerous resources. Simply putting a ban on it would cause the loss to trade and restrict the trade. And even in the case of the state of Gujarat versus Mirzapur Moti Qureshi Kasab Jamaat, it was held, a Supreme Court had pronounced that banning a movie would actually violate the maker's right to Article 19, subclause 1, and also that the bans on the movie under different circumstances have not been imposed on the valid constitutional grounds, but to serve the interest of different groups, whether social, religious, or political. Under no circumstances, bans on the aforementioned nature can be justified. So here again, Yulu cannot be held liable under Section 153A and 295A of the Indian Penal Code. Lastly, if Yulu is convicted under Section 295A and 153A of the IPC, then these two cases show a contradictory relationship between slander and Article 19, subclause 2A of the Indian Constitution. Even in the case of Subramaniam Swamy versus the Union of India and others, sought remedies that could erode the legal framework for hate speech. In this case, the petitioner requested the court to declare Section 153A and Section 295A as unconstitutional. Section 153A penalizes the promotion of feelings of discord or hostility or hatred or malice amongst different communities. And while Section 295A penalizes insults to the religion. These two cases together illustrate conflicting relationship between hate speech law and Article 19, subclause 2A of the Indian Constitution. If your lordships are pleased with the argument, may the council proceed with the prayer.
Learned counsel, there are a few questions which arise and which we expect you to address. One, you have referred to burden of proof when it comes to the criminal cases filed. Well, it is you who has moved the court here under Article 32, right? It is you who are seeking the quashing of the filing of charges against. So, if the burden of proof is on the prosecution, if the burden of proof is on the state to establish, well, that is not supposed to be established here in this proceeding under Article 32. It's supposed to be established during the trial proceedings under those rules. So, on what basis are you seeking quashing of this trial? On what basis are you seeking that this allegation should not have arisen against you in the first place? How can you ask for burden of proof without the trial having been conducted yet?
Your lordships, but however, here it is the allegations that are put forward on the petitioners that we have actually instigated the religious riots, the communal riots, and also that we have maliciously and deliberately hurt the religious feelings of the persons. So if and they have taken the stance of the 6 scenes that have portrayed in the trailers or the teaser of the web series so released on the 1st January 2021. So here the burden of proof lies on the respondent to prove that even if the scene that they're talking about is the lead actor of the movie is throwing away his kada into the sea, so they need to prove beyond any reasonable doubt that the kada that was used for the entertainment purposes by the petitioners is actually the one satisfying their malicious intent to hurt the religious sentiments of the Sikh community.
Learned Counsel, the question was, if that burden of proof lies on the respondents in the present case, or that on the Union of India, or on the state in any sense, now that is not supposed to be done in this proceeding. How are you raising this issue in this proceeding? Is it not supposed to be done in the trial court, where the criminal proceedings are taking place?
Lordships, but the allegations that are put forth in a manner that we have actually disrupted the national security of the state of Indica is a very is of a serious matter, is of the serious nature, and that is why this issue is coming in front of the Supreme Court, and that is why we, as counsel on the behalf of the petitioners, are claiming that even to prove those allegations, you need to first prove that the kada used in the scene was the one used by the as the religious as the religious part on the Sikh community.
No, advocate, try to get Justice Setia what he asked you, since he was challenging that burden of proof lies on the state. That question will arise only at the time of trial, not at this stage. So, on what ground you are challenging that one, that particular point of burden of proof?
Your lordships, but we've not been given an opportunity of trial, and this is beyond what is given in the fact sheet, the Moot proposal.
So then this bench will grant you that option for trial. Go before trial court. You got option.
Indeed, your lordship, but here, since the allegations that are put on the petitioners are way too serious, and that we are threatening the national security of the state of Indica, that is why we have come and approached the Supreme Court for the same.
Okay, proceed ahead.
Much obliged. If your lordships are pleased with the arguments of the counsel, may the counsel proceed with the prayer.
Yes.
Much obliged. Wherefore, in the light of the issues presented, arguments advanced, and the authorities cited, respondent requests this honorable court to adjudge and graciously please the following. Foremost, the petition is maintainable under Article 32 in the Honorable Supreme Court, and it should be heard. Secondly, Article 14 and 19 have been violated. Therefore, Section 3 of the IT Act 2021 is deemed to be unconstitutional. Lastly, the Honorable Supreme Court of Indica is requested to not convict Yulu under Section 153A and 295A of the Indian Penal Code, and pass any such order that this Honorable Court deems fit in the interest of justice, equity, and good conscience.
Learned Counsel, regarding the prayer once again, now this court is hearing you in relation to a petition filed under Article 32. How is the question of conviction under provisions of the Indian Penal Code relevant here? Is it a question of conviction that can arise under a petition that is filed under Article 32?
Since the allegations that are put forth need to be proven in the first place, and we have defended our case, so that is why this prayer says that we are requesting this honorable court to not convict Yulu under Section 153 and 295 of the Indian Penal Code.
Fine, thank you very much. Okay, let's continue.
Permission to begin?
Yeah.
May it please the court, I appear on behalf of the respondent in the case Yulu and OTT Consortium versus Union of Indica. I will be submitting issue 1 and my co-counsel will be dealing with issues 2 and 3. May the counsel refer to the bench collectively as your lordships?
Yes,
please.
Much obliged. Counsel seeks permission to proceed with the arguments before the court.
Yes.
Your lordships, it is humbly submitted before this honorable court that the public interest litigation filed by Yulu and OTT Consortium is not maintainable as there is no infringement of fundamental rights. This petition is just a misuse of the provisions of the public interest litigation, and I shall be submitting 3 reasons to support these claims. The petitions lack public interest. Your Lordship, the Shroud's Judicial Dictionary defines public interest as a matter of public or the general interest and does not mean that which is interesting as gratifying curiosity or love for of information or amusement, that in which a class of community has pecuniary interest or some interest by which their legal rights and liabilities are affected. Your Lordships, it is humbly contended that in the instant case, the petitioners seeking redressal do not seek any advance to public right. Rather, it is being used as a tool to gain media hype and clearly indicates that the PIL goes against the very definition of public interest. It was held in Ashok Kumar Pandey versus State of West Bengal that the attractive brand name of public interest should not be used for the suspicious products of mischief. It should be aimed at redressal of genuine public wrong or public inquiry and not publicity oriented or founded on personal vendetta. Your Lordships, hence it is humbly pleaded that the petition lacks public interest. Thus, such petition filed before the court is liable to be rejected and not be maintainable. Your Lordship, it is humbly submitted before the Honorable Court that the rules given in Section 3 of the Information Technology Intermediary Guidelines and Guided Media Ethics Code Rule 2021 does not violate the fundamental rights guaranteed under Part 3 of the Indian Constitution and is well within the purview of reasonable restrictions that can be imposed in the interest of public order as stated in Article 19.2. Under the article, restrictions may be imposed in interest of specific grounds held in Ramjilal Modi versus State of UP. The Supreme Court explained that while a law may directly not be dealing with public order, it could be read to be in interest of public order. Your Lordships, Supreme Court concluded that the anticipatory action or prior restraint of speech is permissible. Your Lordship, my learned opposing counsel stated that the petitioner apologized and deleted the scenes after backlash, which means two things. First, being that the scene added was not important, never important for the purpose of storytelling, and second, being that it agrees that the scenes were questionable. Your Lordships, aggravated forms of insults to religion have a tendency to disrupt public order, which was held in Ramjilal Modi versus Union of India. Second, being that the content was well within the ambit of fundamental rights, it wouldn't have caused riots in the country. Reasonable restrictions or limited actions are permitted if the speech falls in one or more grounds within the grounds mentioned in Article 19.2. The reasonable restriction means that there must be a balance between freedom guaranteed and limitations. We humbly submit that the rules do strike this balance. Your Lordship,
Learned counsel, a question here.
Yes.
In the course of your argument, you have mentioned that had the contents of the web series been in accordance with or had it been within the scope of the idea of freedom of speech and expression under Article 19, it would not have led to any communal issues or riots in the country. Now, do we expect the public at large in India to be conversant with what freedoms are available to citizens and expect them to always act in accordance or in furtherance of the contents of legal provisions? So how can we conclude, what is the basis of this conclusion, that because public reacted to it, it means it does not fall within the meaning of freedom of speech and expression? As the state, it is your duty to uphold the fundamental rights, uphold the freedoms that have been enshrined in the Constitution. So even if the public is not at the present point of time able to understand the scope of this, should it not be your duty to protect the right of the petitioners here, their freedom of speech and expression, which is guaranteed to them under the Constitution? So how can this conclusion be drawn that because public reacted to it, it means it is not in accordance with the freedom available under Article 19.1?
Your Lordships, the reason why the rules are being introduced after the backlash is because the government is trying to
Now, first,
prevent.
let's limit ourselves to Article 19 of the Constitution first.
Yes, Your Lordship. Uh, the active, the scenes that were
Is
put.
Yeah, is the web series that has been released, are the contents, uh, you know, uh, are the contents falling within the freedoms that have been enshrined under Article 19(1)?
No, Your Lordship, they do not fall within the ambit of
Why?
19.
Why?
One,
Why? That is,
uh, because
and
it's
this is being asked in the context of your argument that because the public reacted to it, because the public, there was a strong backlash against the release of this serial, it means it is not in accordance with the freedom under Article 19(1). How do you justify this argument?
Your Lordship, the petitioner one, Yulu, has a power to reach to huge numbers of consumers, and the communities have um, uh, around the state, all the states of India, expressed their dissatisfaction from the scenes that were shown in the trailer. Therefore, Your Lordships, we submit that it is in violation of the Article 19.
So, if the communities in India are the communities the ones who decide the scope of Article 19, or is it the state that should have a better understanding? And is it not the Constitution which decides what the scope of Article 19 is? How can we say that the communities and their reactions are the basis of the decision or the basis of the assessment as to whether it is in accordance with Article 19 or not?
Your Lordship, the limitations are provided to prevent any future communal disharmony, and that is the intention of the government, Your Lordship. It is trying to prevent any future riots that take place after every release of uh, any web series on the OTT platforms, Your Lordship.
Let's continue.
Much obliged, Your Lordship. In the case of PIL, legal standing has a quintessential connotation, and it is condition precedent for the mentality of petition before the court. Your Lordship, in Janata Dal versus H.S. Chaudhary and others, the judgment clearly states that only a person acting bona fide and having sufficient interest in the proceeding of the PIL will alone have the locus standi and can approach the court to wipe out the tears of the poor and needy suffering from violation of their fundamental rights, but not a person for personal gain or private profit or political motive or oblique consideration. Similarly, if excessive petition under the color of PIL brought before the court for vindicating any personal grievances deserves to be rejected at the very threshold. As submitted through the preceding contentions, this PIL is not a bona fide act and shall not be filed in the interest of general public. Therefore, it is humbly submitted before the Honorable Court that there is neither any public interest involved in filing the PIL, nor is there any infringement of constitutional rights, and hence the petitioner does not have any locus standi. Unless the court has any further questions, that concludes my submission on behalf of the respondents.
I think it's okay. It's okay.
Much obliged, Your Lordship. My Lordship, my co-counsel would like to proceed with her issues.
Please.
Your Lordship's counsel seeks permission to present the second issue before the Honorable Court.
Yes, yes.
Your Lordships, it is humbly contended before the Honorable Court that the Act of Regulating Content, as given under Section 3 of the Information Technology, Intermediary Guidelines and Digital Media Ethics Code, which 2021 is constitutionally valid. Your Lordships, as the above mentioned section of the Act is in consonance with the exceptions stated under Article 19.2 and Article 19.6 of the Indian Constitution. Your Lordships, Article 19.2 and Article 19.6 state that Nothing in Article 19(1)(a) and Article 19(1)(g) shall affect the operation of any existing law or prevent the state from making any law, insofar as such law imposes reasonable restrictions on the rights conferred by the above subclause. Your Lordships, these reasonable restrictions are subject to security of state, friendly relations, friendly relations with foreign state, public order, decency, morality, contempt of court, defamation, or incitement of an offense. Your Lordships, it is humbly submitted that from Section 3, subsection B, points 2, 5, 8, and 11 of the court, it is clear that it is absolutely constitutional on the part of the government of India to curate the IT laws. Your Lordship, these laws have been in fact introduced to uphold the democratic system of the country. Your Lordships, ULU's act of publishing the web series also violates Article 25, that is freedom of conscience and free professional practice and propagation of religion. Your Lordships, Article 25 is also subject to public order, morality, and health. Your Lordships, Hulu's irresponsible conduct in permitting the use of OTT platforms of its company for streaming a religiously, communally, socially, and morally offensive web series shouldn't be granted any latitude from the court. Your Lordships, the ID Rules 2021 are also in consonance with Article 14's Doctrine of Intelligible Differentia. Your Lordship, as this particular doctrine was established in the E.P. Royappa vs. State of Tamil Nadu case, where the conventional notion of equality was challenged. Your Lordship, the reasonable categorization which is being generally followed was challenged in the particular case, and the Supreme Court established a new definition in this ruling. Your Lordships, as movies have always been under the vicinity of Central Board of Film Certification, similarly, as OTT platforms are getting famous, they should be monitored under the IT Rules 2021. Your Lordships, the OTT platforms have in fact tried to regulate themselves from a self-regulatory code, but Your Lordships, it was proven that this particular code was only used for monetary gains, and it failed to be a successful model. Hence, Your Lordship, the government had to step up and invoke some new laws which would be more stringent. Your Lordships, the Act is also in consonance with Section 87 of the Information Technology Act 2000, which is also the parent act. Your Lordship, this states that central government has the power to carry on the provisions of the IT Act 2000. Your Lordships, Section 69 and 69A of the Information Technology Act 2000 are also in accordance with the IT Rules 2021. Your Lordships, Section 69 states that where the central government, if satisfied that it is necessary in the interests of the sovereignty of India, integrity of India, defense of India, security of India, or friendly relations with foreign states, or for preventing the incitement of any cognizable offense, it may, by order, direct any agency of the appropriate government to intercept, monitor, or decrypt any information that has been transmitted, received, stored in any computer device. Your Lordships, hence Your Lordship, it is submitted that from Section B. From Section 3, subclause B, points 2 and 3 of the Moot proposition, it can be concluded that Section 69 of the IT Act is applicable here. Your Lordships, Section 69A of the same Act provides certain powers to the central government to issue directions for blocking for public access of any information through any computer resource. Your Lordship, when the central government is satisfied that it is necessary in the interest of the nation, with the security of the state, with friendly relations or public order, Your lordships, or most importantly, when the government is satisfied that a blocking of such content would prevent the incitement to the commission of any cognizable offence, it may block the particular content. And your lordships, in the same section, it is mentioned that if an intermediary fails to comply with the direction issued above, it shall be liable for an imprisonment for a term which may extend to 7 years, and it may also be liable for a fine. Your lordships, the IT rules 2021 are also in consonance with section 79 subclause 3 of IT Act 2000. Your lordships, section 79(3) of the IT Act actually grants certain exceptions to the intermediaries. But your lordships, there's also in the provision in the same act where these exceptions to escape the liability would not fall. Your lordships, when the intermediary has conspired, abetted, aided, or induced, whether by threats, promise, or otherwise, in the commission of the unlawful act, and your lordships, upon receiving actual information or being notified by the government that any information, data, communication link residing in or connected to a computer resource which is being controlled by the intermediary is being used to commit an unlawful act. Your lordships, Yulu still went ahead with the release of the particular web series, even after knowing that it has instigated a lot of communal riots all across the country. It just deleted few scenes and still went ahead with the release of the particular web series. Your lordships, if just deletion of certain scenes of the web series would have assuaged the matter, would have cleared the matter, then FIRs and complaints still would not have been filed all across the nation. Your lordships, Yulu was well aware of India's heterogeneity and still went ahead and published the web series. It was well understood that it would incite rioting and violence. All of this was just done on purpose for the web series to be popular and controversial and gain business and just be more successful business wise. Hence, your lordship, it is humbly submitted that the particular act would come under section 79(3) of the IT Act.
Learned Counsel 1, now section 3 of the rules that has been formulated after all this, which has been challenged by the OTT consortium. Now that has been challenged on the grounds that it is ambiguous and vague, right? So how do you argue that it is not ambiguous and vague, and why it should not be struck down?
Yes, your lordship. The particular rules 2021 have come into play only to uphold the democratic system of the country. Your lordship, there are a total of 11 points in subsection 3, point B of the particular code, which is given under annexure 2 of the Moot proposition. Your lordships, through several points, it can be concluded that it is well within the ambit of Article 19.2, Article 19.6, and also Article 302, which allows the central government to make certain laws, which would uphold the public order of the country. Your lordship. Unless the court has any further questions, that concludes my submission of the second issue, and I shall proceed to the third one.
Yes,
Much obliged, your lordship. Your lordships, it is humbly contended before the honorable court that Yulu can be held liable under section 153A and 295A of the Indian Penal Code, because it deliberately and maliciously hurts religious sentiments and promotes enmity between different groups of religion on the grounds of religion. Your lordship, as mentioned by my co-counsel earlier, which she claims that they have not hurt the Sikh sentiments, Your Lordship, actually, in the Shirur Mud case, which the infamous Shirur Mud case, the Honorable Supreme Court had in fact established certain essential religious practices, and your lordship's wearing a kada is within the ambit of the 5 Ks which are very important in the Sikh religion. Hence, your lordship, the same scene has shown a Sikh man removing and throwing away his kada in probably frustration. Your lordships, that proves that this is a violation of essential religious practices, and Yulu did not care for the sentiments of the religion. Okay. Much obliged, your lordship. It is also humbly submitted that the cases lodged against Yulu show that merely one person is not affected by the conduct of the applicant and other co-accused. Rather, a number of persons across the country have felt that the web series is offensive, and hence they have filed FIRs and complaints in large numbers. Hence, your lordship, it is not a stray case over some oversensitive individuals lodging the FIR against Yulu and other petitioners, that as stated by my learned opposing co-counsel. In fact, the harm has been done to the larger public. Your lordships, the apex court in the case of Amish Devgan versus Union of India held that the speech or expression causing or likely to cause disturbance or threats to public order or divisiveness and alienation among different groups of people, or demeaning the dignity of targeted groups, it is against the preamble of the Constitution of India. It violates the liberty and freedom and other freedoms that are being given in the Constitution, and it seriously possesses a threat and unity and it seriously possesses a threat to unity and integrity of India, and hence in such case it may be dealt under section 295A of the Indian Penal Code. This has been held by the Honorable Supreme Court, your lordship. Your lordship, it is also humbly submitted that even if there was no regulatory body to grant a certificate, even if there was no regulatory body to grant a certificate, uh, to the OTT platforms for the web series being streamed online, it was the duty of Hulu. It was well within the duty of the petitioner to see that the contents of the disputed movie are disputed web series are not in such that they may be detrimental to social, communal, and religious peace of the country. Your lordships, entertainment at the fundamental rights of large sections of society is not as per as the aim and objective of the Constitution. Your lordships, it is humbly submitted that right to freedom of profession cannot be permitted to override the right to freedom of religion. The submission of apology or withdrawal of certain scenes after its streaming would not in fact absolve the accused person of the offense committed by them. Also, your lordships, it is also humbly submitted that Article 38 of the Constitution of India provides that the state shall thrive to promote the welfare of people by securing and protecting as effectively as it may the social order in which justice, social, economic, and political shall thrive. Your lordships, it is also humbly submitted that the it is the fundamental duty of every citizen of India, as stated under Article 51A, subclause E, to promote harmony and spread common brotherhood amongst all people, not respective of religion, linguistic, or regional differences.
Learned Counsel, before this, I guess you refer to Article 38.
Yes, your
Right?
lordship. Yes, your
So what
lordship.
does Article 38 entail? Could you come back to Article 38?
Indeed, your lordship. Your lordship, Article 38 of the Constitution of India provides that the state shall thrive to promote the welfare of people by securing and protecting as effectively as it may the social order in which justice, social, economical, political, shall inform all institutions of national life.
Right.
And yes, Your Lordship.
So on the basis of this, provision of the Constitution, what is your argument? What exactly are you supporting through this, through the citation of this provision?
Your Lordship, through introduction of Article 38 in my arguments, I humbly submit that it was right on the part of Indica to curate the IT laws, Your Lordship, because these IT laws uphold the democratic functions of the country, and hence, Your Lordship, the government is well within the ambit of the Constitution of Indica to curate the particular laws. That's what my contention is, Your Lordship.
Which part of the Constitution does Article 38?
Yes, Your Lordship. I'm aware that it is under Part 4 of the Constitution of Indica, which states directive principles of state policy. Yes, Your Lordship, the directive principles of state policy are not enforceable. Hence, Your Lordship, all the laws which the government makes should be made keeping in mind the directive principles of state policy, which are mentioned in the Constitution of India. Your Lordship, I feel that they can't be completely ignored, and when the situation
It's
is
not a question of their being ignored. What the thing
yes,
is
Your
that they are
Lordship.
directive principles of state policy, right?
Yes, Your
So at the
Lordship.
time of policy formulation, at the time of framing of laws, well, it is a good idea to refer to the directive principles of state policy, but they should not be a part of your direct execution, right? So they cannot be
Yes, Your Lordship.
converted into executive action right away. So here executive action has been taken against this the petitioners here. So how can that be justified on the basis of Article 38?
Your Lordships, Your Lordships, if Your Lordship, I agree that the directive principle of state policy cannot be formed in the form of cannot be enforced in the form of legislative powers. But Your Lordship, Article 19 and Article 19(6), which are very important, Your Lordship, they are the fundamental rights. And Your Lordships, so these provisions, which are very important in the respect of the in the respect of the security of state, hence, Your Lordship, that supports my arguments that it is well within the ambit of the constitution of the government to enforce these particular laws.
Let's continue.
Much obliged, Your Lordship. Your Lordship, um, Your Lordship, hence it is humbly submitted before the Honorable Court that ULU shall be held liable under Section 153A and Section 295A of the Indian Penal Code because it promotes enmity between groups of people on the grounds of religion and outrages the religious belief with deliberate and malicious intent by insulting its religion or religious belief. The reference to Sindhu gods and goddesses in the scenes in berating light cannot be justified. Therefore, if the state is to secure a social order for the promotion of the welfare of the people who disturb the social order and work against the promotion of welfare of people, hereby should be dealt with formally. That concludes my submission. If your lordships permit, may I recite the prayer?
Yes,
Much obliged, Your Lordship. Therefore, in the light of the issue raised, arguments advanced, and authority cited, it is humbly prayed that this honorable court may be pleased to declare the public interest litigation filed by the petitioner not maintainable, to declare that the petition filed by the petitioner under Article 32 of the Indian Constitution not maintainable, to uphold the charges on ULU on promoting enmity between different groups of people on grounds of religion and outraging the religious feelings with deliberate and malicious intent, to declare that there should be complete ban on such web series, and to pass any other order, direction, or relief that it may deem fit in the best interest of justice, fairness, equity, and good conscience. all of which is humbly prayed by the council of the respondents. Lordship, that concludes my submission.
Yes, yes.
Thank you. Let's move to the rebuttals. Learned Counsel, we cannot hear you. Kindly switch your microphone on.
Yes.
As quoted by my learned opposite counsel, they have stated about the infamous Shirur Mutt case that the person that was shown was sick, and then it followed the series of events that he threw away the kada, and that is that in this case the person was held liable. But it is not stated anywhere in the fact sheet whether the lead actor in the web series was actually a Sikh. So I don't see how this case the council seeks clarification on this part. Secondly, they have mentioned about the reasonable restrictions that they have imposed with the Article 19 subclause 2. But here, reasonable restrictions would be the one if they would have asked us, if they would have asked Yulu to delete the scenes, which they have done. Which the petitioners have done. They have deleted the scenes and then they went forward with the release of the web series. But the council, on the part of the respondents, they want to ban the series, which is an absolute violation of the fundamental right of Article 19, subclause 1G, which is freedom of free trade. Also, my co-counsel will be dealing with the remaining questions.
Okay.
Stating the facts from the respondent memorial itself, they have stated that insults to religion, unwittingly, carelessly, or without any deliberate or malicious intention, do not come within this section. My learned counsel is contradicting their own statement, and the need to prove that the petitioner had a deliberate intention to outrage the religious sentiment of the people. Also, they mentioned that legal standing has a connotation and is a condition precedent for the maintainability of the petition before the court. The appeal is dismissed, and the facts remain unclear as of how they are being related to the present situation. Also, in the memorial, they have mentioned that Yulu, by releasing the web series Chandak, violated Article 25 of the Indian Constitution. That is freedom of free profession, practice, and trade. Whereas in the present case, it was Yulu whose fundamental right was violated. That is, they were restrained that were put on the trade. The learned opponent counsel contradict themselves by this, and this is the same thing that the petitioner is trying to state. It is humbly submitted. They also stated that that even if there is no regulatory body to grant the certificate of fitness of the movies being streamed online, it is the duty of Yulu to see the content of the disputed movie. It should not be in such a way that it create unrest across Indica. The learned opponent counsel has misrepresented the facts and are focused as to who actually certifies as to what is to be published. It is already given in Annexure 1 COCCPs.
If your lordships permit, council seeks permission to go ahead with the rebuttal.
Yes, yes, please.
Okay. Your lordships, I would start by saying that the learned opposing counsel has stated that the particular IT rules 2021 are retrospective in nature. Your lordships, the web series teaser was released on 1st January. The web series, in fact, was then released on 1st February, and the IT rules 2021 were enacted for 21. Your lordships, this is what has been mentioned by my opposing counsel. Your lordships, hence it's proved that the particular rules are not retrospective in nature, and they do not take away the vested rights. Your lordships, hence your lordships, this is not in contravention with Article 14 as stated by the opposing counsel. Also, your lordships, they've also mentioned that there are certain instances in where various web series like Sacred Games, Patal Lok, Mirzapur, they have similar incidents of protest and disagreements during the period of their release. Your lordships, these particular rules are in fact curated so that this does not happen again and again and again and again. Communal rights are not spread again and again. The burden on the judiciary is not made. Your lordships, also stated by the opposing co-counsel that it was nowhere mentioned in the series that the particular actor was Sikh. Your lordships, it is clear that a person wearing a turban, probably, and wearing a kada and throwing the kada in such a way that it shows that the particular person was a Sikh and he wanted to throw away the kada, and this was what has been showcased in the particular web series your content. Uh, hence your lordship, it is understandable that the man was a Sikh. The Sikh community is the only community in India who wears a kada for religious purposes, your lordship. Also, your lordships, the opposing co-counsel states that there would be a loss of business revenue. Your lordships, even after stating the fact that the restrictions on the web series and the demand for ban on the web series is well within the ambit of the most important constitutional provisions, that are Article 19 and Article 302 and Article 25 as well. Your lordship, still the opposing co-counsel contends that it would suffer suffer loss in business revenue. This justifies, your lordship, that the petitioners.
Learned counsel, let's limit the sub-rebuttal to issues which have been raised in the rebuttal.
Your lordship, indeed, your lordship. Also, your lordship, your lordships, removal of a particular scene or issuing of an apology does not ends under criminal laws, your lordship. The petitioners would still be held liable under section 295A and section 153A of the IPC, your lordship. Because, your lordship, when they deleted the particular scenes, a guilty verdict has already been entered when they issued an apology. Hence, your lordship, it can be concluded that the petitioners had mens rea and had actus rea as well. Your lordship, also, section 153A prescribes enhanced punishment in the place of worship. Your lordships, here Yulu committed the act of showing public display of affection of two particular people within the background of a temple. Your lordship, if the particular place would have not been a temple and probably some other place, probably the riots would have not been instigated. But Yulu, knowingly that it will instigate riots, they purposely showed the particular scene within the background of a temple.
Learned counsel, let's limit the sub-rebuttal to issues which have been raised in the rebuttal.
Your lordships, actually, I lost the internet connectivity in between. Can the learned co-counsel repeat the particular contented issues?
No. Just in case
it's not possible.
Okay, so your lordship, much obliged. So, also, your lordship, there are certain things in where the opposing co-counsel has only stated half of the facts in favor of favor of their particular issue and have not stated the entire act where the court has actually in certain cases the opposing co-counsel has not mentioned all of the issues, all of the judgment.
What does it mean by quality judgment?
Your Lordship, that conclude so my submission on Sir
No, no, advocate. What does it mean that quantity judgment, quality judgment?
Your Lordship, I apologize, but you're not audible to me.
No, just now you said something about the qualitative judgment. What does it mean?
Qualitative judgment?
Yeah. You said something about that, no? That the judgment.
Not aware of,
no, you said that the judgments relied upon by the other side are not qualitative judgment. You can use the word relevant or irrelevant. I think there is some internet issue.
Yes, yes, the device.
Okay, push it ahead. Because we have heard you at length. You are supposed to only reply, especially to the law, that to again law point. You are not supposed to repeat the facts. Yes, please go ahead. I think there is some technical issue with your device. It's okay, beta. It's okay.
Apologies, Your Lordship. My co-counsel has some internet issues.
Yeah. It's okay.
Be joining soon.
It's okay.
Your Lordship, am I audible and visible now?
Yes, beta. Yes, advocate, we can hear you.
Yes, I'm sorry, Your Lordship. There was some network issue on my part. Can you repeat the question, Your Lordship?
No. I think it is not necessary to repeat the same question. Only thing that it was a suggestion by this court that you may refer relevant or irrelevant judgments. That's all. Do you want to submit anything more on this point, or the points raised by your opponent?
Lordships, is there any question for the council?
No. At least from me, there is no question.
Okay, much obliged, Your Lordships. Your Lordships, that concludes my submission.
Thank you. Yes. What is next now? Sitya sir, what is next now?
I think we can bring our hearing to a close.
Yeah. So arguments are concluded now. There is nothing remain for argue by the advocates. So now what is next now?
This draws the final round to a conclusion. All the participants will be leaving and joining the valedictory link at 4:45. Judges, if you want to wait back and discuss on how to score the teams, you can do so. The rest of the participants and the viewers can please leave the meeting. Thank you so much for joining. Please join the valedictory ceremony link at 4:45.
Okay, thank you.